Hey guys, I hope everyone's doing really good. It's go do your own research. It's still so hot. I have to make this a quick one tonight, I promise you, because I'm sweltering. But we have some updates on what is going on with Nikolas versus Brian Friedman, and what is going on with her attorney, Tony Scammer Buzbee, versus Jay-Z and Rock Nation. Actually, Jay-Z's attorneys. So I actually saw this from the same account that I was looking at the other night when I was talking about the Damori Perez Desiree Hadley case. I have to make sure I get those names right. It's called Document Tings on Twitter, and they posted an update. So I didn't even know that this case in Texas was going on between the Buzbee law firm and Quinn Emanuel, which is Jay-Z's attorneys. Yeah. What's his name? Alex Spiro, who defended Megan Thee Stallion. This is all MAGA versus Rock Nation, and it goes back to, like I said in previous live streams, this journalist called Liz Crokin. So yeah, let me quickly show you this guy because I want to give credit to my source. There it is. So it's called Document Tings. This is from June 23rd. I actually realized, because I was looking through their account today, and I actually realized I used to watch this person on YouTube. They have a YouTube channel where they just read through court documents, because they were covering the Megan Thee Stallion versus that weirdo blogger Milagro. What's his name? I'm terrible with names. I think it's Graham's, who's working for Tory Lanez. He was covering that case, and I was listening to it on YouTube. So yeah, he posted on June 23rd, court update. The Harris County Court has granted multiple motions to dismiss under the Texas Citizens Participation Act in the consolidated litigation involving the Buzbee law firm, Quinn Emanuel, Urquhart and Sullivan LLP, Marcy Brian Croft, MJ Legal, PA, Jose Maldonado, and Gerardo Garcia. I tried to look up those people, but I couldn't find out who they are, so please forgive me. But I think what's gone on here is Tony Buzbee has tried to sue Jay-Z's law firm, and he's flopped, just like Brian Friedman did. So the fact that these two are now going head to head, I think they've met each other's match, because Brian Friedman has filed a response to Alexa Nikolas's lawsuit against him, and she has been called for a sanctions meeting because she has failed to serve the other people she's suing. So the judge wants to know what the hell's going on, but we're going to get onto that in a second. So yeah, I didn't know that this was going on in Texas, because obviously I'm watching the docket of the Jay-Z versus Tony Buzbee in SDNY, which is still very, very much active. The orders are tied to consolidated cause number 2024-81902 in the 11th Judicial District Court of Harris County, Texas. I'll just put that picture back up for you. Oh, I forgot to say, actually. Good evening, Janessa. It's Janessa, isn't it? Yeah, she said she better leave Jay-Z alone. Yeah. First it was BJ Investigates, now it's Alexa Nikolas. White girl privilege, if you ask me. Okay, I know I'm white, by the way, but... Right, so... Where was I? The order dismisses all claims brought by the Buzbee law firm against the Croft defendants with prejudice. This is all of these cases consolidated together that he was suing, all of them. They've all been dismissed with prejudice. In a separate order involving Jose Maldonado, the court again granted the Croft defendants' TCPA motion to dismiss. That order dismisses all of Maldonado's claims against Marcy Bryan Croft and MJ Legal with prejudice. The court also granted a version filed by Quinn Emanuel. That order dismisses all of plaintiff Gerardo Garcia's claims against Quinn Emanuel with prejudice. So that was that one. Yeah. And then at the bottom, it says, it is further ordered that all of plaintiffs' claims against defendant Quinn Emanuel on the above captioned case are dismissed with prejudice. It is further ordered that defendant Quinn Emanuel shall be awarded all costs and reasonable and necessary attorney fees. And that's the judge's signature. Yeah, so what's funny is that one of the accounts that I was looking at, so if you watch my last live stream, which was about how these Twitter troll accounts have been identified associated with crypto payments. I know it's pretty deep, but I'm following it all. There was an account named on there called Come With Facts, and she was also tweeting about this Tony Buzbee Jay-Z case. Now, according to her, it was dismissed for a lack of jurisdiction. Okay. It's funny how she's part of the same network that is posting anti-Rock Nation and I'm sorry, I have to say it, it's pro-domestic violence, pro-domestic abuser people, and trying to manipulate the narrative in favor of these people like Tory Lanez and Desiree Hadley's husband. Okay, each order states that the moving defendants are entitled to recover costs and reasonable and necessary attorney fees for the Croft defendants. The amount of costs and fees will be decided later after supplemental evidence and a further court order. The Quinn Emanuel order also awaits costs and reasonable and necessary attorney fees. Full documents below. So this is a good account to follow if you want to get an unbiased report of what's actually going on. Okay, so now let's get over to what is going on with Alexa Nikolas's lawsuit where Tony Buzbee is representing her, because that's what I want to cover tonight. So we have this document from June 10th, 2026, from the Superior Court of California, County of Los Angeles, and it says Alexa Nikolas versus Brian Friedman et al. For plaintiffs, David Christopher Fortney via LACC. That is Tony Buzbee's partner. So it says here, nature of proceedings, case management conference. The matter is called for hearing. The court and counsel confer regarding the status of the case. The court finds that plaintiff has not filed a proof of service establishing service of the summons and complaint on defendants within 60 days of the filing of the complaint. Yeah? So she's had 60 days to serve the complaint she's filed to the defendants, and she's failed to do so. And that's what's really interesting. As soon as I saw this, I was like, this happened with Kat Tenbarge. She filed a lawsuit against Kat Tenbarge, and then she couldn't serve it. She had a lot of difficulty serving it. And then she got like the PI, the process server, to do a 24-hour stakeout on one of the addresses that they thought was associated with Kat Tenbarge. Anyway, eventually she did serve her, but it was probably cutting it fine. So it's really interesting now that this judge is pulling her up. Therefore, the court sets an order to show cause, why sanctions should not be imposed due to plaintiff's failure to file a proof of service of the summons and complaint on 28th September 2026. Plaintiff must file any responsive papers at least 5 calendar days before the order to show cause. The court may impose sanctions against plaintiff or counsel for plaintiff at the time of the order to show cause if counsel for plaintiff or plaintiff fail to appear or fail to give good cause for the delay in serving the summons and complaint. Case management conference is continued on 28/9/26 in Department 207 at Beverly Hills Courthouse. All parties shall comply with California rules of court regarding initial and further case management conferences. In particular, all parties shall adhere to the duty to meet and confer, and to the requirement to prepare and the case management statements. Counsel for plaintiff shall give notice, okay? So then we had someone needs to go and tell that subreddit, Celeb Legal Drama, as well, that they are on the wrong side with this one. But Brian Friedman, he is using Ellen S. Garofalo, who was one of the Justin Baldoni attorneys, has filed an answer to her first amended complaint. Yeah. So remember, in the last live stream I did about Alexa Nikolas, she had filed a second amended complaint. Alexa Nikolas plaintiff versus Brian Friedman, Melissa Nathan, and John Doe's 1 to 100 defendants. Complaint filed February 5th, 2026. Defendant Brian Friedman answers plaintiff Alexa Nikolas' first amended complaint as follows. General denial. Pursuant to California Code of Civil Procedure, defendant denies generally and specifically every allegation of the complaint. Affirmative defenses. First, affirmative defense. I don't know what any of this means, but it's very interesting that he has filed this response rather than a motion to dismiss. I don't know if he's playing chess, not checkers, but I don't fancy their chances because I'm telling you, yeah, Tony Buzbee is even more sloppy than Friedman. And he files these lawsuits with no business doing it. And then he literally just drops his client in it. And like I said, he's had it in for Jay-Z since, where are we now? October 2024 is when this all kicked off. As a first affirmative defense to every course of action in the complaint, defendant alleges that plaintiff's complaint fails to state facts sufficient to constitute a cause of action against defendant. As a second affirmative defense to every cause of action in the complaint, defendant alleges that plaintiff's claims are barred, in whole or in part, by the applicable statute of limitations. I think we mentioned that. I think I might have mentioned that, or someone mentioned it. She's left it way too long. Including, but not limited to, California Code of Civil Procedure, sections, whatever. Third affirmative defense. As a third affirmative defense to every cause of action in the complaint, defendant alleges that plaintiff claims are barred in whole or part by the doctrine of latches. No idea what that is. As a fourth affirmative defense to every cause of action in the complaint, defendant alleges that plaintiff's claims are barred in whole or part by the doctrine of unclean hands. That's an official legal term, by the way. It's not just that she doesn't wash her hands. That's probably true as well. Would I buy a second-hand car from any of the two? I wouldn't buy a bottle of water off any of these people. Thank you so much, Pizza Boss. I'm doing my best. Honestly, it's really, really uncomfortable in the UK right now. We are not used to this weather. This is the hottest it's been and the longest it's been this hot consistently. And we're not equipped for it. So I do apologize for the noise, but I cannot close the window and the blind is kind of hitting the window a little bit. Yeah, no, the other thing I wouldn't do, is have them represent me. That's another very important point that people need to start understanding. Because you see how they manipulate their publicity to make themselves look good. They're actually ripping off their clients, and they go out and they appear on the news and they appear on all these podcasts and websites, and so they become famous, and so people think they're going to do a good job, and they're not. They're just going to rip people off because they're scammers. Okay, let's get back to what Brian's saying. As a fifth affirmative defense to every cause of action in the complaint, defendant alleges that plaintiff's claims are barred in whole or in part by plaintiff's consent, ratification, and/or acquiescence to the acts and omissions alleged in the complaint. Okay. As a sixth affirmative defense to every cause of action in the complaint, defendant alleges that to the extent defendant engaged in any of the acts alleged in the complaint, such acts were excused, justified, and/or privileged. I mean, I did say I think this is freedom of speech. I don't know if that's what that means, but it sounds a bit like it. Excused, justified, and/or privileged. As a seventh affirmative defense to every cause of action in the complaint, to the extent any statements are attributable to defendant Friedman, so they don't actually have definitive evidence or proof linking the website to Brian Friedman. Such statements constitute protected expressions of opinion, rhetorical hyperbole, or are otherwise non-actionable under the First Amendment to the United States Constitution. That's what I said. It's free speech. I'm sorry. You all want free speech. And Article 1, Section 2 of the California Constitution. As an eighth affirmative defense to every cause of action in the complaint, defendant alleges that plaintiff's claims are barred in whole or part in that plaintiff waived whatever rights it may have had to assert the claims alleged in the complaint. Waived whatever rights? I don't know what that means. Oh, thank you. There's no noise. Yeah. We could do a whole episode about the heat wave if you want, and how many fires are going on right now, and how many pedos are being locked up. But no, we'll just stick to this. Okay. I've had to turn my camera off because it's just too much. As a ninth affirmative defense to every cause of action in the complaint, defendant alleges that plaintiff's claims are barred in whole or part in that plaintiff is estopped from asserting the claims alleged in the complaint. So I've definitely come across that word before. I forget what it means right now, but I think it was in the Blake Lively case. As a 10th affirmative defense, how many is there in total? My God, Brian Friedman wasn't messing around when he he's written 27 affirmative defense. So I'm just guessing here that this is a much stronger action than just filing for a motion to dismiss, because he's thinking, I ain't letting this one fly. Where are we? Failure to claim. Yeah, I thought that might be one as well. Okay, I read that one. There we go. As a 10th affirmative defence to every cause of action in the complaint, defendant alleges that plaintiff claims are barred in whole or part in the defendant fully performed, satisfied, or discharged any duty owed by defendant to plaintiff. Defendant fully performed, satisfied, or discharged any duty owed by defendant to plaintiff. Okay. The 11th affirmative defence is that defendant's performance of any duty or obligation owed to plaintiff was excused. 12th affirmative defence to every cause of action in the complaint is that the relief sought in the complaint because of... Wait, what? Let me say that again. Plaintiff is barred from the relief sought because of plaintiff's inequitable conduct. So she hasn't followed due process, I guess. This is one I pointed out. Plaintiff has not been and will not be damaged or entitled to recover damages of any type or kind in any amount whatsoever. He called her a... What did he call her? Something like... Oh my God. It wasn't a part-time public figure. It was something like... He basically said, look, she ain't even a proper public figure. She's somewhat of a public figure. But yeah, I mean, she hasn't lost money since this website appeared. She literally created her YouTube channel after the website. Plaintiff was bound to exercise reasonable care and diligence to avoid loss and to minimise its damages, if any, and that plaintiff may not recover for losses which could have been prevented by reasonable efforts on its part or by expenditures that it might reasonably have made. Defendant alleges that plaintiff's injuries or damages, which defendant denies, were proximately caused by the conduct, acts, omissions, activities, carelessness, recklessness, and negligence of plaintiff and or others to bar, in whole or in part, the damages sought herein against defendant. As a 16th affirmative defence to every cause of action in the complaint, defendant alleges that plaintiff's claims are barred in whole or part because any injury or damage suffered by plaintiff was not the result of any act of omission of defendant, but was the result of the intervening or superseding action of others. I think we've covered that pretty extensively. No one that I know that has beef with Alexa Nikolas has ever talked about... Well, they might have mentioned the website, but they certainly didn't act on anything that was in it or really said too much about it. They had already made up their opinion way before it came into existence. And then, you know, she did herself a huge disservice by how she carried on with the Drake Bell situation. It's really as plain as that. Who, by the way, people on Celeb Legal Drama, who claim to be a survivor-friendly space, She dragged up a teenage victim's sealed testimony from a trial that was over to prove that she was right in being friends with Drake Bell. I know you don't know it, but it's true. And I've already seen, I've mentioned this, I think I mentioned this before, that there was a right-wing channel that took up this story, not this story, the story that she was suing Kat Tembarge in defense of Drake Bell. This guy was saying, Kat Tembarge is a nut job. She's a loony lefty nut job. And Drake Bell must have been framed because Kat Tembarge went after him. You know, it was that kind of a narrative going on. Okay, so 18th is plaintiff's damages, if any, were proximately caused by the conduct of persons other than defendant for which defendant is not responsible or over which defendant has no control. Can't argue with that. I'm sorry. Plaintiff's damages, if any, were proximately caused by the conduct of plaintiff and or her agents. I think her husband and mum might have been involved. The defendant alleges that plaintiff's claims are vague, ambiguous, and uncertain. Well, yeah. That's definitely on brand for Alexa Nikolas to be vague, ambiguous, and uncertain. Defendant is entitled to an offset for damages caused by plaintiff acts, omissions. As a 21st affirmative defense to every cause of action in the complaint, defendant alleges that to the extent plaintiff receives any recovery in this situation, defendant is entitled to an offset for damages caused by plaintiff's acts, omissions, breaches, and or conduct. There you go. I had a feeling that was going to be his motive. As a 22nd affirmative defense to every cause of action in the complaint, defendant alleges that the principles of equitable estoppel bar or diminish recovery against defendant. So I think estoppel is referring to, it's coming back to me now, it's when a point has already been made and you can't change it after it's been submitted into the court, into the filings or something like that. As a 23rd affirmative defense to every cause of action in the complaint, defendant alleges that plaintiff's claims are barred in whole or in part by plaintiff's failure to join all necessary parties. That is also true. Oh my God. That was not done in that complaint. There was no joining of dots. There was a lot of pretty circumstantial evidence by a external party that we don't really know where they came from. 24th affirmative defense. In the complaint, defendant alleges that defendant Friedman did not act with actual malice. Okay, so he's saying no, there was nothing malicious about that. To the extent any statements are attributable to defendant Freeman, they were made with knowledge that they were false or with reckless disregard of whatever they were false or not. To the extent plaintiff is, oh, yeah, this is it. To the extent plaintiff is a public figure or limited purpose public figure by virtue of her public advocacy and media presence, plaintiff cannot satisfy the actual malice standard required to sustain her claims. She didn't just start her YouTube channel, but while this website was active, she was going on channels like, was it Entertainment Tonight? You know, big entertainment podcasts to promote this NBC program called Quiet on Set. But, you know, she was having a bit of a moment there, but it's definitely calmed down since then. I'd say her trying to drag Kat Tenbarge and Adam McIntyre on that live stream that really sealed the end of her YouTube channel career, really. Because, like, for example, if she had talked about the Justin Baldoni case and actually knew what she was talking about, she could have carried on doing that, but she just doesn't do any research or knows what she's talking about. He's right. She talks in very vague and I can't remember what the words were, but yeah, she keeps it all very vague and uses a lot of buzzwords and hyperbole. But the other thing about these smear websites, yeah, is just because someone is criticizing someone on a website, you can't necessarily say it's a smear website. It's up to the individual, it's up to the public to investigate whether they think that is true or not. You don't have to like take it at face value, but sometimes people do this as a genuine form of whistleblowing. And I've already said, I think on my last live stream about this, that there's another website called Rain on Your Charade. And I'm sorry, that's not a smear website. It's literally laying out the entire facts of Alexa Nikolas's legal history, all of the cases that have been dismissed because she didn't have good cause, for people to read and study for themselves. Like, it's not a smear campaign. A smear campaign is when you see hundreds of comments. If you want to know about a smear campaign, yeah, come and look at the comments I get on Michael Jackson videos. Come and look at them shaming victim statements, which Alexa Nikolas was doing. Bringing up Amber Heard, you know, that's when you know there's a real live smear campaign going on. Right. Did I read 26? Defendant alleges that plaintiff's own conduct, including her own public statements and social media activity, contributed to and proximately caused any damages she allegedly sustained, and any recovery should be reduced in proportion to plaintiff's fault. I told you he ain't playing. And another little thing I found was, you know, on Reddit, because she definitely built up a lot of support using Reddit before she had her YouTube channel. I could only find one post about the website and it had like maybe 3 comments. So again, she definitely was reaching with this complaint. Okay, 27th affirmative defense to every cause of action in the complaint. Defendant's assertion of specific affirmative defences herein does not constitute a waiver of any other affirmative defence not asserted herein, and defendant reserves the right to assert any applicable affirmative defences disclosed by their investigation and discovery in this matter. Oh, he's going for investigation and discovery. Wherefore, defendant prays for judgment as follows: that judgment be entered in favour of defendant for an award of fees and costs incurred by defendant herein, and for such other and further relief as the court deems just and proper. Dated June 15th, 2026. Okay. And then he's got his proof of service attached. Service list, Anthony G. Buzbee. Read it and weep. Read it and weep. The fact that this is clogging the legal system, I know. I mean, all of her lawsuits have been a complete waste of legal resources, and she picks on people that she thinks don't have the money and power to fight her. Well, as I said, I think they've met their match here. But I don't want to lumber myself with any false predictions or anything. So I'm going to wrap it up because it's so hot. I really hope that anyone who's watching found this interesting. Thank you very much, Pizza Boss 2024. And I'll see you all soon. I am going to do another live stream. My next live stream is going to be about Michael Jackson again, because I've now found out, you see how they all edit their Wikipedias so you can't find background information on people, right? The publicist that I found, Michael Citrick, who worked for Epstein and the Michael Jackson estate for years, well, I found out he worked for R. Kelly as well. So I'm going to do a little live stream on that, hopefully tomorrow. Okay, guys, thank you so much. See you all later. Bye.